So we're going to start with our session today. It is a great honor for me to welcome Professor Vicki Jackson. Professor Vicki Jackson is currently the Lawrence Tribe Professor of Constitutional Law at Harvard Law School. You may notice that in our invitation, it said that she was the Thurgood Marshall Professor of Constitutional Law. That changed very recently. Professor Jackson received her JD from Yale University, where she also was the editor of the Yale Law Journal. And she formerly, before joining Harvard, she taught in Georgetown, where we met many years ago. And then she moved to Harvard, and the name Thurgood Marshall must have been something very special for Vicki, because Vicki clerked for Thurgood Marshall in the Supreme Court. So she knew Justice Marshall personally, so I'm sure she must have been particularly pleased with that name in her chair. And last but not least, we have been friends for many years now with Vicki. And that's why I'm very, very happy to have her here. She was, while teaching, particularly in Georgetown, professor of several Argentinian scholars. Some of them are very distinguished nowadays, Manuel García Mancilla, for example, and Sofía Sagüez, two of them that have now a very distinguished career in constitutional law. Without anything else, I will give the floor to Vicki. Vicki will hear you with great pleasure.
Well, thank you very much. Can you hear me okay?
We hear you perfectly.
All right. Well, Ricardo, thank you so much for the invitation. It's wonderful to have this occasion to see you, even remotely. A very distinguished constitutionalist who has, if I'm remembering right, didn't you come and guest lecture in one of my classes over the years? And we hope to have more occasions like that. Thanks as well to the Universidad de San Andrés for inviting me, and Dean Vasquez and Professor Russler and the others involved in putting this seminar on. Thanks to all of you who are in this Zoom meeting for your interest, and special greetings to my former students and to my colleagues from the International Association of Constitutional Law. My plan for today is to start out with a little background for why I'm talking about this. Then introduce the claim I'm making and try and define some key concepts. Then I will discuss 4 questions. First, what counts as a knowledge institution? Second, why focus on knowledge institutions in constitutional democracy? Third, why focus on institutions rather than individuals? And finally, whether there are principles shared across knowledge institutions that we might identify. In closing, I will try and sketch some possible implications of this general framework. All right, background. In the last decade or so, we have seen rising authoritarianism and illiberalism in countries once regarded as solidly free and democratic. There are a number of trends associated with this. 4 of them are identified by scholars Aziz Hook and Tom Ginsberg. First, attacks on independent courts, on law, and other institutional checks. They offer a chilling example, a statement by the honorary speaker of the parliament in Poland saying, "It is the will of the people that matters, not the law." Second, efforts to undermine the competitiveness of elections, manipulation of districts, manipulation of hours, problems with counting votes, problems with voting. Third, the centralization and politicization of executive on the autonomy, meritocratic orientation, expertise, and impartiality of the bureaucracies that make up so much of modern government. Why are these important? Well, they suggest bureaucracies provide an entry point for professionalism and expertise. They help limit political patronage being used to manipulate elections. And they have a Burkean tendency to slow down any major change that any newly elected leader may want to put into effect, which can have its upsides and its downsides. An extreme example in Turkey involved the purge of thousands of police officers, private school teachers, soldiers, judges, university deans, and 22,000 Ministry of Education officials. The fourth trend they identify is what they call the shrinking of the public sphere. What does this mean? Attacks on journalists, attacks on the media, attacks on academics, Venezuela, Turkey, Poland, Russia, and a wide variety of means being used to carry out these attacks. A colleague of ours from the International Association, Ibrahim Kaboglu, was an early victim of such attacks in Turkey, where he was criminally prosecuted for writing a report on minority human rights violations in the Kurdish area. In Hungary, after the 2010 elections, we've seen dismantling of many systems, less press freedom. The Central European University was essentially kicked out of Hungary. The Academy of Sciences was taken over by the government, and there's been a dramatic decline in press freedom. In Poland, there have been attacks on courts and on critical voices in universities, including criminal and civil prosecutions for defamation against a world-known constitutional scholar, Wojciech Sodurski, who has professorships both in Warsaw and in Sydney, Australia, and who sometimes teaches at Yale. Now, Ginsburg and Hook make this argument, with which I agree. The practical operation of liberal democracy, they say, requires a shared epistemic foundation, where information is systematically withheld or distorted by government so as to engender correlated population-wide errors. Democracy cannot fulfill this epistemic mandate. But governments are not the only threats to the development of a sound and shared epistemic foundation. There are economic threats to serious investigative journalism, which has been a trend for many decades. So you see a great decline of serious independent journalism in many cities across the United States. Further concerns arise from the concentration of news distribution through social media systems that are based on often unknown algorithms. And of course, the widely noted tendency of social media to contribute to the rapid spread of false information. Public distrust exists of both academic expertise, of news media, and sometimes this is fanned by charismatic political leaders. But there's a long-standing history of this kind of distrust in democracies. A historian named Sophia Rosenfeld, in a short book called Democracy and Truth, A Short History, argues that over the last 200 plus years, truth in democracies has been a place of contest, veering between popular or populist and elite understandings. And she argues that truth in democracies has to be understood as the product of what she calls multiple constituencies, pursuing it according to various methods and continually open to fresh challenges and revision. Well, all this brings me to the question of, if the practical operation of constitutional democracy requires some shared epistemic base, a base that is under threat both from some governments and from other forces, economic, technological, and social, how do we sustain, maintain, and protect those epistemic capacities? How can reliable knowledge be created and tested and disseminated in constitutional democracies? All right, that's my background. My basic claim is that knowledge institutions are fundamental to the success of constitutional democracy. They contribute to a knowledge ecosystem through institutions that span the public and the private sphere. They are not a branch of government, nor should they be, but they are an essential component of constitutional democracy. They include universities, the press, elementary and secondary education, libraries and museums, public and private, some government offices that collect and publish data, some private NGOs that do the same. Because of their centrality to both the democratic and the constitutionalist components of constitutional democracy, the field of comparative constitutional studies needs to develop a nomenclature to capture and conceptualize this boundary crossing but essential set of institutions. All right, that's my basic claim. Now, a bit on my working definitions. Knowledge. I am not a philosopher, but I looked a little bit, and in philosophy, a widely accepted view is that knowledge is a justified true belief, and that justification exists if a belief arises from generally reliable processes. Naomi Oreskes, who's a historian of science, has said that reliable processes have two major elements. First, practices and procedures designed to ensure that the process of review and correction are sufficiently robust as to lead to empirically reliable results. These would include things like peer review and tenure. But she says it also depends on having a sufficiently diverse scholarly community because, she argues, the social character of science forms the basis of its approach to objectivity, and therefore the ground on which we can trust it. A good pragmatic definition of knowledge is found in a recent statement by the Association of American University Professors. There, the association said, "We define knowledge as those understandings of the world upon which we rely because they are produced by the best methods at our disposal." As Professor Peter Byrne, a colleague of mine from Georgetown, has written, the very idea of scholarship presupposes a goal of truer knowledge. I like the phrase truer knowledge because it implies that knowledge is neither static nor certain, but the best understanding possible in a given context and time. Now, these definitions do not necessarily privilege universities or scientific institutes. A responsible press might be regarded as a knowledge institution, working within more constraints of time and resources than scholars, and producing much more contingent and revisable forms of knowledge. All right, institutions. Of course, knowledge is produced not only in institutions, but by all sorts of individuals and in many contexts. But I focus on knowledge institutions for reasons I'll get to in a minute. For now, let me say by knowledge institutions, I mean those meeting three criteria. First, an institution is some sort of relatively ongoing, relatively stable entity. Second, the entity is devoted to the production or dissemination of knowledge as one of its central purposes. And third, the institution applies disciplinary standards designed to produce reliable knowledge. All right, the last term I will speak to is constitutional democracies. For these purposes, I'm adopting a pretty minimalist notion. I mean a polity committed to regular, free, and fair elections, to those liberal rights that are widely viewed as necessary to free and fair elections, which include rights, freedom of speech, press, assembly, political participation, and very broad adult suffrage. And finally, enforcement mechanisms to secure and maintain those rights and to fairly apply the laws. These are typically courts. All right, now let me elaborate on some of these. And now I'm coming to the four questions I mentioned at the beginning. First, what counts as a knowledge institution? So I'm now going to apply my three criteria: ongoing entity, principal purpose includes knowledge production or dissemination, and third, according to disciplinary norms. So universities and the organized press, I think, are easy cases. Although the disciplinary norms of academia and of journalism differ, and they work on different timeframes, each is devoted to the pursuit of knowledge. Each has disciplinary norms for the verification of data or information before publication. And constitutional texts not uncommonly protect both freedoms of the press and academic freedoms. South Africa's Section 16 protects freedom of expression, which includes freedom of the press, as well as, quoting again, academic freedom and freedom of scientific research. Other constitutions extend protection to universities as semi-autonomous institutions, in addition to or instead of recognizing individual academic or research freedoms. So in Brazil, Article 207 says universities enjoy autonomy with respect to didactic, scientific, and administrative matters, as well as in financial and patrimonial management. Colombia's constitution, Article 69 and 71, provide autonomy for universities and freedom in the search for knowledge. Croatia guarantees the autonomy of universities. Finland says universities are self-governing. Now, we all know that texts by themselves do not determine the level of actual protection, but they are a data point. Now, let me turn to government offices, which I mentioned before, because I don't know that they would be on everyone's first list of knowledge institutions. But government organs, in the US, a Census Bureau, a Tax Bureau, a Ministry of Agriculture, a Bureau of Labor Statistics, a Bureau of Justice Statistics, these all exist. And they are typically charged with the collection, verification, and publication of data in their subject areas. They are sometimes specifically charged by statute to act objectively or in accordance with scientific rules. Such offices typically employ professionals in the relevant fields and do so for the purposes of obtaining reliable data. They thus meet my three criteria for being a knowledge institution. Now, constitutions around the world are increasingly providing for what some call fourth branch institutions. Professor Mark Tushnet, who's a giant in our field, calls them institutions to protect democracy. And these institutions are very interesting, but their focus has typically been on things like electoral integrity, very important, anti-corruption, very important, and human rights, very, very important. But so far, I have found few constitutional provisions establishing government agencies or entities that have clear jurisdiction to protect the knowledge functions of government offices. There are a small number of constitutions that have relevant, I'm going to say, aspirational statements. So, for example, Kenya's Constitution of 2010 includes among its guiding principles for government leadership, quote, objectivity and impartiality. Andorra's constitution says the public administration serves the general interest with objectivity. The Dominican Republic provides that basic principles of conduct for the administrative state include objectivity and transparency. And Argentina's constitution in Article 75 requires that the allocation of funds among the different levels of government should be based on objective criteria. But there are very few references that I have found to institutions set up by constitutions whose charge includes promoting accurate and objective work on knowledge in public administration. Now, some countries have codes of ethics, as in the UK, that address the need for objective and accurate treatment of information. The UK Cabinet Manual has principles that say it is of paramount importance that ministers give accurate and truthful information to Parliament. Ministers who knowingly mislead Parliament will be expected to offer their resignation. And it lists 7 principles of public life, and among those 7 are objectivity and honesty. But objective knowledge-producing responsibilities of government offices are really not widely recognized in constitutional texts, so far as I've been able to determine. So if people who are listening know of things I should look at, please let me know. Let me turn now to courts. Constitutional scholars are more accustomed to thinking of courts as bodies that either resolve disputes or say what the law is. But courts also generate a kind of knowledge. Witnesses take oaths to tell the truth, the whole truth, and nothing but the truth. Witnesses are subject to questioning. An immense amount of law is devoted to evidence and the procedures for and review of fact-finding. So courts plainly have as one of their aims the determination of the truth of the matter, in particular disputes. And they have disciplinary procedures for doing so. In some court systems, those procedures are adversarial. In some, they are more judge-directed. But there are disciplinary procedures that exist. So I would count courts as knowledge institutions. What about legislatures? This may sound like a strange question to you, but in US constitutional literature, claims are sometimes made about the purportedly superior fact-finding ability of legislatures as compared to courts in understanding broad social conditions. I do not think US legislatures should be viewed as knowledge institutions. They do aim at times to produce knowledge through open public hearings, and they are ongoing institutions. But at least in the United States, they entirely lack disciplinary standards designed to produce reliable knowledge. I've been asked about social media and internet-related websites, and I think some might be, for example, Wikipedia. It's not a social networking, but it is a collective internet-based way of pulling information together, and it has developed over time standards that might justify treating it as a knowledge institution. But the conventional social media like Twitter or Facebook, I would be inclined to think not, even though they do contribute to what we know about the world. But again, they don't have disciplinary standards devoted to determining what is true. At least I don't think they do. So, or at least right now. So much for the institutions I include. Let me turn to my second question, which is, why do I focus on knowledge institutions and in constitutional democracies? Okay, the range of what I regard as knowledge institutions is broad, but it's not as broad as the range of institutions that promote the free exchange of ideas and information. That would include many communications technologies that do not have the knowledge-oriented filtering or disciplinary standards I've discussed. So why am I focused on knowledge institutions rather than focusing more broadly on all channels of communication, which are clearly of great importance? And I guess the reason why is sort of summed up in something that the historian Sophia Rosenfeld wrote when she wrote about what she called democracy in an age of lies, in which the challenges to the existence of objective facts and the increasing fragmentation of popular understanding of what seemed to me to be objectively verifiable facts raise what she and I regard as particularly acute challenges. Now, knowledge institutions are central to any government's ability to govern effectively. Even the most autocratic government will require forms of knowledge to exercise and maintain their own power. There's a wonderful example Stephen Holmes calls attention to in Jean Baudin's writings, arguing that a reason for absolute monarchs to give immunity to people speaking in Parliament was to increase the monarch's knowledge of what was going on so the monarch could maintain power. But knowledge institutions, I claim, are of especial importance in constitutional democracies. The democratic component of democratic constitutionalism contemplates the active involvement of citizens. On thin versions of democracy, citizens check decisions of those in power. On thicker versions of democracy, citizens participate actively in influencing government bodies' agendas and policy outcomes. On either version or others that lie between, knowledge relevant to evaluating representatives and to the policy choices confronted must be accessible to voters. Knowledge institutions are also central to the constitutionalist component of democratic constitutionalism. Now, constitutionalism here might be taken in a very simplified sense to refer to the application of the rule of law to government. Central understandings of the rule of law all require that the laws and what the laws require be knowable, and that laws be enforced with some degree of consistency and reliability. So knowledge of the law about what it is and how it's being applied and how it can be improved are, I claim, all necessary to securing the constitutionalist part of constitutional democracy. All right, constitutional democracies then are particularly dependent on the production and broad dissemination of knowledge. Dispersed knowledge is necessary not only to the development of policy, but also to securing the rule of law. These knowledge institutions merit our independent constitutional attention. This is not to say that individual rights are not important, but I think there are a couple of reasons to focus on institutions. So I'm up to question 3. Why focus on institutions? Given that individuals play key roles in developing and expanding and testing and communicating knowledge. So why focus on institutions? And let me offer 2 reasons. The first comes from recent work of scholars Mila Versteeg and Adam Chilton, who have argued in several articles and now in a book that has just come out this summer, that when organizations are given or are a special location for the exercise of rights, those rights may be better enforced. So, for example, trade union rights, rights of religious groups, rights of political parties. And the enforcement mechanisms they think exist operate not just in courts and not just through voting, but through other kinds of pressures these organizations can bring to bear. They explain that organizations can provide focal points for collective activity, that organizations can overcome collective action problems when lots of individuals are expected to act for themselves. And in this way, organizations can impose costs on governments for departures from rights more easily than separated individuals. Now, universities, the press, and government offices are not within the Versteeg-Chilton paradigm of what are the most effective organizations. They're focused on membership organizations like trade unions and parties and religious groups. But nevertheless, I think as organized entities, these knowledge institutions may well be able to contribute to the protection of individual rights of free speech, free research, free and informed voting, and the like. Academics who work in universities, civil servants who work in knowledge-generating offices, journalists employed by major publishers may all be both empowered and protected by working within the legal ambit of their entity. And their entities and those who lead them have some incentives to maintain their existing functions and capacities. Okay, second reason I focus on institutions has to do with the dangers of allowing governments to use their coercive power to promote knowledge production and especially knowledge testing. As we have all too vividly seen in recent days, authoritarian governments around the world have used the COVID epidemic to assert coercive control over the reporting of what the governments say is fake news. Now, there's a lot of false stuff circulating, but in these countries, you see the folks being targeted under these laws are critics of government responses. And you see this in Hungary and the Philippines and Russia, and I could go on. So it's dangerous to put the government in charge of determining true knowledge. On the other hand, testing and authentication of the justifications for beliefs that something is true, those are essential to producing good knowledge. Having institutions that lack the power to put people in jail, but have the soft power to determine what counts as good work, whether it's an editor questioning a journalist and fact-checking, or a faculty member challenging another faculty member's work in their area. These seem to me much less dangerous ways of trying to promote the search for knowledge with fewer risks of suppressing that very search. Now, a caveat here before I get to my fourth question. Institutions and institutional design can only do so much. Almost any institution can be subverted if it's controlled by persons who do not have a democratic constitutionalist temperament. So the character traits that are valued in a society may bear on the likely success of its institutions. I'll suggest later that civic education may be a partial response to this challenge. The fourth question is, are there any common principles that I would apply across this wide range of knowledge institutions? Here are four that I've tentatively thought about. First, an aspiration to impartiality and objectivity in working towards better understandings. Second, a commitment to apply relevant disciplinary or professional standards with appropriate independence. Third, an attitude of epistemic humility and openness to having one's beliefs disverified. And finally, a commitment to a plurality of sources so that not all knowledge institutions are controlled by the same power holders. All right, so those are my four questions and my current answers. Let me talk in the last part of my discussion about the possible implications. This work I see as a book project. I right now have a list of 7 possible implications. I will briefly name them and then close my talk by focusing on one of them. First, I urge recognition of a general constitutional obligation, even if it is not a justiciable obligation, an obligation to protect the institutional sources of knowledge on which democracy rests. Second, I urge recognition of a government duty, again, it may or may not be justiciable, but a government duty to act based on objective evaluations of relevant knowledge, and relatedly, a presumptive, though not an absolute, duty on the part of government not to lie about what the facts are. Third, I argue constitutional doctrine should be better developed with respect to the protection of journalists, especially journalists who are in a working relationship with an ongoing press institution. That setting will make it easier for courts to evaluate claims that a journalistically reliable methodology has been employed. Fourth, constitutional doctrine with respect to government speakers, people working in government offices that have access to knowledge. That doctrine needs to recognize the really important role of some government offices in promoting democratic knowledge. And this is the one I'm going to come back to later. Fifth, all constitutional actors, and here I would include courts, legislatures, the executive and administrative part of government, and as a recent paper by Leora Lazarus argues, constitutional scholars. We should all be considering how to incentivize improvements in legislative and administrative knowledge, advancing goals of democratic competence, like those discussed by Professors Robert Post, Bruce Ackerman, and Cass Sunstein. Sixth, in earlier work, I have argued that courts are an impartiality resource for fact-finding in a time when faith in facts and institutions has declined. And I think courts should consider how to improve their own procedures, both for checking fact-finding elsewhere in government and for improving fact-finding in the courts themselves. Seventh, and finally, attention must be given to the quality and quantity of what is sometimes called civic education. This is not just for lawyers, but for everyone. I mean this in a broad way, to include rights, courts, voting, elections and representation, the structures of government, norms of equality and non-discrimination, which I think have to prevail in any constitutional democracy, the idea of reasonable disagreement and of tolerance, something about how facts are developed and tested, the distinction between facts and opinion, and the rudiments of what I will call critical thinking. So this is kind of a rich agenda for civic education, and I think it should be embraced at all levels of education, elementary, secondary, and university, and not limited to law schools and government departments. All right, the last part of my talk takes one of these and elaborates a little, and I'm going to talk about government employees who have responsibilities to produce knowledge or to act in accordance with professional norms. As both Ackerman and Post have argued from different perspectives, knowledge-based competence is an important component of democratic self-government. Effective, competent government, I say, is both a purpose of having a constitution and a necessary prerequisite to the protection of individual rights and to enabling the pursuit of happiness, to which the U.S. Declaration of Independence famously refers. To make good decisions, good knowledge is required. So I have two observations here. The first is about an area of the U.S. Supreme Court doctrine, so may not be of broad interest, relating to government employee speech. It's an area where I think the U.S. court has gone sadly astray. And then one comment on structure, how executive and administrative offices are structured. And both of these are informed by my vision of such government offices as part of constitutional democracy's knowledge infrastructure. All right, as I see it, civil servants have two public capacities. They are employees subject to legitimate supervision within their offices, and they are public servants ultimately accountable to the public. Usually, the latter role as public servant is best served by complying with managerial supervision. Democratic control and accountability is exercised typically from the top down, elected officials through senior officials, and so on. Professional competence goals are also typically served by orderly development of factual understandings and policies within executive or administrative offices, but not always. Sometimes higher-ups will have incentives to mislead, to skew the facts presented to the public, or to suppress facts inconsistent with their policy agendas. Sometimes public employees may feel they are participating in acts that violate norms of honesty and candor, or that violate the legal rights of citizens. In a case called Garcetti against Ceballos in 2006, the U.S. Supreme Court held that statements made pursuant to a government employee's official duties are not protected by the First Amendment from adverse government employment action, apparently even if they address matters of public concern or matters of professional ethics and constitutional responsibility. The court said, restricting speech that owes its existence to a public employee's professional responsibility does not infringe any liberties the employee might have enjoyed as a private citizen. It simply reflects the exercise of employer control over what the employer itself has commissioned or created. That is, the government has control over government speech, even if the individuals in a government office have very different ideas about what is right. The implications of this decision for faculty, for professors teaching at public universities, aroused considerable concern, although the court explicitly said it wasn't deciding how this would apply to faculty. Now, putting the question of public academic people to one side, seeing government offices that exercise expert or professional judgment as part of a group of knowledge institutions would favor a much more generous understanding of the public's interest in the speech of government employees about matters within their professional or expert knowledge than the Garcetti decision seems to produce. To treat these employees as unprotected from managerial discipline for their speech about their government jobs seems to me a mistake, given both free speech values and the more general importance of knowledge institutions in democracy, for three reasons. First, as I've already noted, government officials, like other employers, have incentives to avoid acknowledging their own mistakes. Government offices subject to supervision by elected officials may have incentives to advance the political interest of the representative rather than the more general public interest in accurate knowledge. Such pathologies undergird important elements of existing free speech doctrine, including the ban on viewpoint discrimination, which is designed to protect the rights of speakers to criticize the government. But such speech critical of the government will be of much less value if important information about government operations is held too tightly. Second, as scholars like Heidi Kitrosser suggest, government employees may be able to contribute special value to democratically held knowledge and discourse by virtue of what they learn in their jobs, like the prosecutor in Garcetti, who thought the defendant's rights were being violated. In scientific and economic fields, research runs across academic departments and government offices in ways that would be artificially restricted by failing to recognize the public value in the governmental speech. Third, with respect to government employees whose position relates to professional knowledge and expertise, like lawyers or doctors or scientists or accountants, there are significant costs to their ability to do their jobs, and thus to their government offices effectively fulfilling their mandates, if those employees are penalized simply for reaching professional judgments that diverge from those of their supervisors. So I think employees in government offices that collect objective or scientific data or exercise professional judgments should have some degree of protection from adverse action for simply providing information or analyses consistent with the competent exercise of their professional expertise. And this is threatened by Garcetti. At the same time, governments as employers have undoubted interests in being able to manage their own workforce, including the ability to discipline employees for errors or incompetence. But as a number of scholars in the US have argued, these legitimate interests can be accommodated through doctrine that does less harm to the interests of the public and the kind of information government employees should be able to provide. Fred Schauer and others have suggested that a category like government speech should not be deployed to immunize careful attention to the really competing values at stake in situations like Garcetti, which involve, on the one hand, managerial authority to discipline employees for work-related errors, but on the other hand, the interest of having the professional and expert judgment of professional employees exercised on behalf of public values. A very different approach seems to be taken in the European Court of Human Rights. According to the Council of Europe, the ECHR case law includes 6 criteria for protecting public disclosures of information that the employer wants confidential under their Article 10 right to freedom of expression. First, the disclosure should correspond to a strong public interest. Second, there's no other effective means of remedying what's wrong without making the disclosure. Third, the public interest is strong enough to override a legally imposed duty of confidentiality. Fourth, the damage from the disclosure can't outweigh the public interest in having the matter disclosed. Fifth, the disclosure should not be motivated by a personal grievance or expectation of personal advantage. And finally, in making the disclosure, the person should act in good faith and in the belief that the information is true and that it was in the public interest to disclose it. Now, I don't know how the Garcetti case would come out under this test, But this approach seems to me to ask the kinds of questions that sensitivity to the role of knowledge institutions, both within and outside the government, should produce. Much more so, I think, than the US approach, which severs the public employee's accountability to the public from its conception of the responsibility of the public servant. Now, second point, much more briefly. In addition to re-understanding speech rights of government employees in the broader framework of knowledge-producing institutions, constitutionalists might give some attention to the idea of separation of functions within government offices. If one could separate fact-finding, fact-keeping, and statistical analysis from more politically motivated policymaking, there might be some benefits. This is not to say that these functions are entirely separable. They are not. But one might, for example, seek to promote the reliability of data collection processes by limiting the power of non-civil service political supervisors to require modifications of data. This is merely illustrative of the possible implications of better understanding the system of knowledge institutions and constitutional democracies. I look forward to your questions and comments. Thank you.
Thank you, Vicki, for your excellent presentation. Somebody might have noticed that Vicki seems to be walking. Now that is because she stands when she speaks instead of sitting because of her back problems, if I remember correctly.
You remember absolutely correctly. Yeah.
Okay, we have several questions. I will start with a question from the president of our university because I have to keep my chair. So I will give him the priority. His question is it healthier for democracies to have both public and private knowledge institutions? In other words, are the risks derived from the existence of predominantly private or public knowledge institutions? So is there something to be preferred?
That's a great question. I think the way I would answer it is to say that I think the healthiest system is probably to have some of each. But if one looks at situations of rising authoritarianism, it's usually easier for the head of government to grab hold of government-controlled offices. And having that in mind suggests the importance of having at least some private sector sources of knowledge institutions, which, licenses can be pulled, private institutions can also be attacked. But consistent with my interest in having a plurality of sources, I think a healthy system is one in which there would be both public universities and private universities, and in which most countries have some form of government media, but having privately controlled journalistic sources is healthy. Same thing, I think, for museums, for libraries, where we gather knowledge and spread it. So that would be my first cut at an answer.
Okay. And the second question is, would you consider constitutional court as knowledge institutions, considering that they produce some sort of knowledge about the constitutions through the process of adjudication? And if so, would you consider those courts as institutions that could produce constitutional knowledge with an acceptable standard of objectivity?
As an abstract matter, yes, I would regard constitutional courts and Supreme Courts as institutions capable of producing knowledge about the law. And if they are decent courts, they will be applying procedures that are presumably generally designed to provide a full and fair airing of the issues. We know that courts vary widely in their procedures around the world, but there are I would say some common elements about hearing before deciding and so forth. So I do think that they are knowledge producing institutions. I might be challenged by someone who says, well, but is it really their purpose? Is it a central purpose to produce knowledge? I just read a book, an old book by a guy named Joseph Goldstein. And the book was called The Intelligible Constitution. And he was a professor at Yale Law School. And it was the argument of this book that one of the very important functions of the US Supreme Court was its function in helping people understand the decisions, understand the content of constitutional law. So in that narrow sense, I would say, yes, they are a knowledge institution. But relating that question to the first question, we would want to have people who are not part of the court commenting on and either agreeing or disagreeing with court's decisions and explaining their implications. So you want to have a diversity of sources around even what may look like authoritative knowledge about the law.
Right, great. Just a minute. Is it possible to achieve an adequate interaction between knowledge institutions and legislatures for the latter to pass laws based on true information and not mere political criteria? Yeah,
that's a great question, and I think it's a really hard question. And I don't mean to be avoiding it, but what I think I honestly have to say is that I don't think I know enough to answer. I have some knowledge from being in the United States and watching what happens that, as I said in my lecture, the United States Congress lacks a system of consistent disciplinary standards for how it approaches the gathering of information. Now, the Library of Congress in the United States was established, I want to say, in the early part of the 19th century in order to make knowledge available to Congress. I don't know when it was established, but there's something called the Congressional Research Service, CRS, produces reports that are pretty decent at the request of members of Congress. Those reports are not necessarily made public, but frequently are. But the reason I'm hesitant to really fully answer the question is that I am not sufficiently familiar with the practices of legislatures around the world. Do I think it's possible for legislatures to be organized to act on the basis of reliable data? I think it's possible to be so organized, but I don't know, and then I would change my evaluation, but I simply don't know enough about the practices of legislatures around the world to want to say anything further.
The point is, if do you consider knowledge institutions only categorized by your three standards? Isn't academia substantially different from NGOs, even if NGOs comply with the three requirements?
Yes, academia is different from NGOs. For example, I don't think most NGOs provide something equivalent to the institution of tenure, which exists at least in many American universities. NGOs don't typically have a widespread faculty deliberation on who gets hired and who gets promoted. So yes, there are differences, and I don't mean to suggest there are not differences. There are even bigger differences between universities and the press. But the criteria that I'm using are intended to explain why I see the institutions that I talked about as, in a sense, part of the same ecosystem, even if they are distinct entities, and they surely are. So it's not my suggestion.
Shut up, nigga.
All of the legal rules for these institutions should be the same. That, I don't think that. But it is my suggestion that there are some common elements to these institutions that play a vital role in constitutional democracy, and that there are some common principles that we ought to be recognizing about and thinking about whether within the context of the particular institution there are implications for doctrine or for structure.
Okay.
Did I answer the question, Ricardo?
Yeah.
Okay.
I have here. There's a question, and I will add a comment from myself. There's a question. It's not my question, but I will add something to it. The question is: don't you believe that even universities can also fall under the spell of producing not knowledge, but fake knowledge? And my point here would be: who decides what is? Because that is one of my concerns. And that is something that here in Argentina is being discussed a lot these days. And I believe in the United States also these days. Who decides what is proper to be said, what is proper knowledge? Because sometimes there are people, for example, the cancel movement seems to be not accepting even knowledge, and these are opinions normally that are expressed by people that do not share the views of certain people. Perhaps the majority, that's fine, they can be the majority, but let's remember that in Nazi Germany, they used to burn books because they believed that they were not adequate for the German people. So that's basically the whole concept of the question.
So here's how I'm going to answer the question. I'm probably not going to engage with all of the controversies you alluded to, Ricardo. Do I think universities can fall under the spell of fake knowledge? Yes. Do I think any human institution can produce knowledge that turns out to be wrong? Absolutely yes. What you want to look for, I think, is what kinds of methods are used to determine what is knowledge. That's why I like Professor Burns's phrase, truer knowledge. We may be mistaken in our beliefs. What's important is to have methods for testing them, to be open to people challenging what people think they know, and engaging in a process of testing. It is also why I think having a plurality of sources, private, public, multiple different journalists, multiple different universities, is also so important to the health of the epistemic community in a democracy. So there is no one source that any in human terms that we can look to tell us what we can be sure forever will be understood as the truth. But it doesn't mean it's not worth trying. It doesn't mean we should give up on the aspirations for an impartial search for better understandings. That's what I think.
Fair enough. How do you achieve real impartiality from governmental departments that are supposed to provide knowledge? In Argentina, sometimes, and I believe you made some reference to it in the United States, but here it's more acute. Most of the governmental offices that are supposed to produce data, they're subject to political direction. Do you think there is a way in which you can reduce that political influence and rely to the data produced by those departments?
Well, I think that's a great question, and it's a complicated question, and the beginnings of an answer, I think, would lie in thinking about an independent civil service. Very few constitutions that I'm aware of make the independence of the civil service a matter of constitutional stature. Not in the United States, and in fact, until somewhere around the 1880s, so almost a century in to the existence of the current constitutional regime in the United States. It was not until then that laws were passed, ordinary statutes, creating an independent civil service with blind graded exams for getting hired, and objective criteria for promotion, and protection from being removed or disciplined without good cause. Now, those kinds of provisions could be ineffective if you're in a context in which you don't have independent courts to enforce those requirements. So is an independent civil service a complete guarantee? No. There are no complete guarantees with respect to human institutions. But that is a start. And then I think to more fully understand the very good question you or someone else just put on this, I would need to know more, and we would need to know more, and be able to talk about the sociology and the psychology of developing a kind of spirit of independence and pride in a particular office and its traditions. I have seen that happen. I know it exists because I've seen it in some prosecutor offices, but I've also seen it come under assault in the United States when we disconnected, but that in addition to the legal component of having civil service protections, which I tried to describe, there are psychological, sociological components of developing pride in what an office does and in being associated with it, which I have seen exist in some offices in the United States. Those are vulnerable to being attacked, but they can become, for a time, self-sustaining. You get virtuous cycles going on. But I think the core of it is to have some legally enforceable protection of the civil servants from the changing political representation that gets elected. That would be the start for how you do it, I think.
And related to that, here's a question that I find really interesting, which is, don't you think that giving too much weight to knowledge institutions would undermine the legitimacy of democratic elective leaders? I think that's a great question in my view, because it addresses the balance between one thing and the other.
Yeah, well, I'm not arguing that knowledge institutions should make laws or adjudicate disputes. And so arguing that they should be protected from interferences with their research is a very different matter than arguing that they should be given coercive power. I think early in my talk, I quoted scholars who were quoting someone in Poland, the Speaker of the Parliament, and saying, all that matters is the will of the people, not the law. That is not a constitutionalist system, but a system in which I'm not arguing for, but in which some university is given power to make the laws for everybody, would not be a democratic system. But Michael Ignatieff has a paper a couple of years ago arguing that universities should be regarded like courts as counter-majoritarian institutions. And I don't really agree with that. I agree with his point that for them to fulfill their function, they will sometimes do things that will evoke public hostility, that they're fragile in that way. But I see knowledge institutions as actually part of what keeps a democracy strong. Asking people to vote when they don't have knowledge about what's going on isn't going to lead to well-informed democratic decision-making that will lead to people's lives being better. So I don't see as much of a tension between protecting knowledge institutions, whether it's universities or the press, as some people, and democracy, as either the question implied or as some people might argue.
Yeah. Okay. I have several further questions. Do you think that in the US, either at federal or state level, your views or your proposals are being endorsed or fostered, or are you in the minority? And this doesn't mean, I don't think the question is just focused on what governments are doing, because I think we all realize that these things, governments usually don't like these things, but generally, for example, the academia or independent people, do you think they share your proposals, your views?
Well, I only have started writing on this in the last year, and so I doubt that very many people outside of the community of comparative constitutional law and a small number of U.S. constitutional law people are even aware of my argument that we should think about this group of institutions together and in a principled way. But I don't think I am alone at all in raising concerns about protecting, for example, the capacity of government offices at the federal level to do objective work, to not sanction government scientists who, for scientific reasons, have reached conclusions that politicians disagree with. There's widespread concern about that. With respect to the press, I certainly press organizations are very, very concerned about the environment in which they're working. I mean, in the last period of time, 5 to 10 years, the number of physical attacks on journalists, deadly physical attacks on journalists around the world has increased. And I think the environment in which leading political figures refer to journalists as enemies of the people contribute to that. But I don't have a broader sense of that issue. And in terms of universities, I think the universities, at least in the United States, for the most part, remain quite committed to principles of academic freedom, to principles of respecting diversity of viewpoints. And I think there's, controversies at the margin, but I think they are quite firm and clear on that. And universities have played a significant role in opposing some measures being taken by the federal government that they think are inconsistent with their interests as academic institutions. So I think what they have done, in a sense, illustrates some of what I think is special about the role of institutions in protecting the knowledge-generating capacities of a democratic system. But I don't think that my particular work is as yet terribly well known, although I've been happy a couple of people seem to be looking at it and referring to it. Study on levels of support for universities. Do you think universities are good for the United States? And you were getting numbers up until about 2015, 2016, 70% of most people, most groups said yes, which was good. At that time, a split developed that hadn't existed before between the responses of people who identified themselves politically as Democrats and those who identified themselves politically as Republicans. And the levels of support for the general proposition that universities were a good thing went down among those who were Republican, not among those who identified as Democrat or, I think, independent. But I think the gap may be narrowing again. I haven't looked at the studies in a couple of years, but that kind of partisan split in whether universities are a good thing, I thought was very, very worrisome. But I know that many people in higher education also thought it was very worrisome. And I believe they are engaged in various outreach efforts to try and address it. And if you go deeper into these same surveys, there were things like, well, what did you think about your own college education? And, oh, that was good. And so it wasn't like a deep well of hostility, but it was something concerning. But I don't know about comparable studies of public attitudes of the press. And when you have political leaders who seem to act and speak in disregard of well-established scientific facts, it does create problems. That influences people. And I think the emergence of those kinds of leaders in various places in the world lend force to the importance of this general project. You know, whether my approach is the right one, I don't know. But I do think political leaders can encourage people to want to make knowledge-based decisions, and they can encourage people to ignore knowledge-based decisions. So I would like to see a democracy where more voters think knowledge matters.
There's a related question with this that says that, don't you think that it could be dangerous to give the press too much weight, or to give too much weight to knowledge institutions, including the press, taking into account that sometimes their views are biased?
Everybody's views are biased in some way or other. Who are we going to give weight to otherwise? It's not a better world to just say we only want to hear from elected representatives without lots of press of differing views, liberal, conservative, progressive, looking at what the government does and saying this is good, this is not so good. We don't want to live in a world where there's only one newspaper that we all have to read and agree with. We don't want to live, I don't want to live in a world where there's just one university and its ways of doing things have to be the right way. Again, I will return to something I said before. I am not proposing, and I don't know anyone who is, that the press or universities or museums be given lawmaking power or the power to decide how to implement the laws that affect other people, or the power to adjudicate the disputes that we bring to our civil courts. So I worry that without a diversity and a plurality of sources of knowledge, we are at risk of any one source having too much weight. But I don't think the risks come from saying that the press as a whole, with its diversity and plurality, needs to be protected.
Yeah, I totally agree with your view. I would like to hear more. This is the question. I would like to hear more on the concept of knowledge ecosystem. The idea of ecosystem seems to call for a certain equilibrium. How this would work? Is it possible to talk about knowledge ecosystem without including non-institutional production of knowledge?
That question is a very good question, and I think the correct answer would be that a study of the entire knowledge ecosystem would have to include individual producers of knowledge. We've seen the importance of guys working in their garages, right, and the development of some of the major channels of communication through which we learn things in the world. So I think I'm not going to try to undertake a description of the entire ecosystem because I think it's too big for me to achieve in what remains of my lifetime. But my claim is that these institutions are interrelated. So sometimes when I've been talking about this, people will say, well, why are they related? And I would ask you to think about how many times, or many times I've read a journalistic article, and the journalist has called up academics who know something about water pollution or about building codes. How many times have we been at conferences where it's not just other law professors, but it's lawyers and maybe police chiefs, people from other parts of the world who know things. So how many times have academics looked at journalistic work to help them figure out the world? How many times do I go to the website of a reliable NGO, and then an NGO I think is reliable that has a different ideological perspective? So I rely on other institutional sources, and I think they do. And I think in the world of economics, the people who have academic appointments and then who work in treasury departments or in tax departments, there's a tremendous amount of back and forth in which we learn better when there's openness between those institutions. So I do think there is that kind of interdependence. But the questioner is absolutely right. Individuals play a very important role, and a thorough study, which I certainly think is worth doing, I just don't think I can do it, would include individuals as well.
You addressed this next question in your talk when you talked about populist governments, and what would be, in your view, the best way to counter argument? Because if you see the situation in the United States, in Mexico, in Argentina, this doesn't seem to be a matter of being on the right spectrum of the political arena or the left spectrum of the political arena. It seems that populist governments share a certain common basis in trying to attack knowledge institutions. Do you think so? And what do you think would be the best strategy to counteract that?
Well, I'm not going to claim expertise on strategies for combating governments. Too big a question, but let me say this. I think that in a sense, I think what I'm arguing for is the importance of maintaining a commitment to the role of knowledge and reasoned decision-making under conditions in which principal actors are open to the possibility that what they think they know is wrong. Now, that's not an attitude that lots of people have. But I think it's an attitude we could use more people to have in running our constitutional democracies. And it is that attitude and the belief that reason and knowledge have important roles to play in deciding major issues of public policy lies underneath this project. I am not saying that reason and knowledge are the only factors. There are a range of reasonable decisions people can take about a very wide range of policy matters, and those get and should get worked out in political life. But what concerns me greatly is the attitude that some folks who hold power have, that seem to be that the facts of the matter don't matter. And I think that constitutional scholars should stand up for the proposition that better understandings of the facts do matter. And even if we turn out to be wrong, we should have systems in place and attitudes in place that will enable us to correct that. Now, this is very different in some ways from appeals in politics that are purely, that ask people only what they're feeling. I don't mean to say feelings aren't important. They are important. But asking people to make public decisions based only on emotion without a reason-based counterpart working in there is concerning.
I was saying that this is an unfair question, and you can tell me so. That's it's adequate if you want to answer it like that. But I'm very concerned about these measures taken by certain governments that try to impose a certain truth and try to criminalize what they believe is spreading lies about that truth. And let me give you an example. For example, the Holocaust, which, of course, nobody can deny that it happened. But you know that in certain countries, particularly in Europe, it's criminalized to deny the Holocaust. Same thing has been proposed here in Argentina regarding the number of people that were disappeared by the military dictatorship. What are your views about that?
So I have a policy, Ricardo, of not commenting on developments in other countries unless I have spent a lot of time studying and thinking about it. But what I will say is this, and this may be because I grew up, my first legal system is the system in the United States. And the United States jurisprudence has a pretty heavy presumption in favor of allowing all sorts of speech, false speech, hateful speech. And with respect to speech that is claimed to be false, I think my general approach would be to say there are substantial risks to allowing governments to use the coercive power of the state to determine truth. I think I said that in my lecture. And so I think one would need to have a very, very weighty and particular reason to support a coercive law that defines truth. But I don't want to rule out that such very, very weighty reasons might in particular circumstances exist. But my general orientation is to say that letting governments decide what is the truth about anything is dangerous, which is why I prefer what I called the sort of much softer power of institutions like universities and the press and museums that can't put people in jail, but can say, this isn't good work. This isn't reliable work.
I told you it was an unfair question. I knew that, so thank you very much for your answer. I promise you that we would end before approximately at 7:15 our time, 6 your time, and I'll keep my promise. I want to thank you for being with us. I want to apologize again to you and to all the participants for this incredible interference that we had. Unfortunately, these things happen in this type of meetings. We try to do our best. Thank you to all the participants, and I think it has been an honor, and we've learned a lot. Thank you very much, Vicki.
Well, thank you for having me and for giving me the honor to speak with you all. And I hope everyone has a good and safe weekend.
Thank you. Thank you.
Bye.
Good night, everybody.
Good night.